Matt, we'll do your bill first. House Bill 6201.
This is part of the Attorney General's package. This one allows for families of children affected by childhood lead poisoning to recover 3 times the actual damages, known as treble damages in legal circles, which would create another mechanism to encourage compliance with existing law. I don't want to go too far into this, but obviously the state was one of the only entity in the country to ever sue lead paint makers some time ago. I was actually in the courtroom when the verdict came down in the favor of the state, but it was overturned on appeal. So it continues to be an ongoing issue for many, many folks. And despite the fact lead paint was taken off the market, I believe in 1978, it continues to be a very significant issue that I've run into in my legal practice in the past. This is a good bill. I'll let the Attorney General expound further, but this bill allows for those folks who are suffering from the effects of considerable of lead paint and lead poisoning to recover, another avenue to recover beyond civil suits, to use the statute in question to recover damages where appropriate.
Thank you, Chairman. This act would require landlords to register certain identifying information on a statewide registry, and for pre-1978 properties, provide a valid certificate of conformance with the Lead Hazard Mitigation Act. For landlords who don't comply, this act establishes civil penalties and prevents the landlord from suing a tenant for non-payment of rent. Committee members, Rhode Island has the second highest serious lead poisonings in New England. We are all familiar with the permanent consequences of lead poisoning. Even a slight decrease in lead poisoning can improve educational outcomes and significantly reduce health and criminal justice costs. But please don't assume that this is an urban problem, because in my town, 1 out of 20 first graders have been lead poisoned. And in the other town that I represent, which is Lincoln, it's 1 in 14. This impacts our entire state. So the solution is strengthening compliance with our lead laws, and this is one mechanism. I know we can get this done, and I ask that you reserve all your wonderful questions for the people from the AG's office who have come today. Thank you.
Okay, and the next bill is House Bill 6238, sponsored by Representative Morales, also an AG bill. You want to put it in play?
Yes, thank you, Mr. Chair and members of the committee. I'm excited to discuss House Bill 6238, as it is based on the basic principle that all tenants and renters across our state, regardless of socioeconomic status or zip code, deserve to live in a home that is safe from lead hazards and any form of exposure. Now, unfortunately, headline after headline, we continue to hear stories, specifically about young children who have been exposed and been poisoned by lead found in the dust, soil, or paint of their home due to the negligence of the respective landlord. Now, as a general reminder, our state's comprehensive lead hazard mitigation law requires that owners of rental properties built before 1978 have a certificate of conformance for each unit that they rent, indicating that their units are lead safe. Furthermore, the certification has to be renewed every 48 months. Now, despite having a clear law in place, however, we are still in a situation where we have far too many landlords who don't maintain their certificate of conformance and have lead hazards present within their rental units. And while we would like to believe that there is always strict and immediate enforcement regarding these violations, that is not always the case, as it requires the tenant to contact their local code enforcement office, which is just of many steps to even get a formal violation filed. This is especially stressful in a city like Providence, where we have a shortage of code enforcement, and at times, they're not even responsive. So this is why I'm excited to have partnered with the Office of the Attorney General to introduce House Bill 6238, as it would allow a tenant to petition to a court, and if successful, establish an escrow account with the clerk of the court, where they would be able to redirect and deposit their rent whenever their leased property is not compliant with the lead hazard mitigation law. The deposited funds would only then be released to the landlord once the landlord has provided the evidence that they are compliant with our state's lead hazard mitigation law. So as a result, this escrow account would incentivize property owners to urgently pursue lead mitigation and maintain a lead-free environment. Much more effective than a slap on the wrist from code enforcement would ever do. Furthermore, there are tenant protections in place explicitly stating that the tenant cannot be evicted on the basis of petitioning to the court because no one should have to face or fear retaliation for trying to live in a safe home. Modeled after existing legislation in Maryland that has been in place for the last 23 years, this policy tool has proven to be effective as it has reduced lead poisoning cases amongst children in Maryland by 95%. And given that lead poisoning continues to be a serious issue, both within urban and rural areas alike, it's important that we pass this legislation to ensure that we're improving compliance around our existing lead prevention laws, increase the amount of safe housing units, and ultimately reduce the number of children and working families who have had to experience the tragedy of lead poisoning. Thank you. Mr. Chair and members of the committee, I will now be introducing on behalf of Representative June Speakman, House Bill 6062, which proposes a comprehensive Bill of Rights for tenants, which would help address some of the most serious common obstacles that renters face as it relates to high rents and a lack of protections. Now, I want to first acknowledge that while we do have landlords that are compliant with our general laws, in addition to being conscientious of the rent increases that they put their tenants through, we're still in a situation where thousands of Rhode Islanders are being taken advantage of. They're being taken advantage of, especially in a tight market where rents continue to increase, and as a result, we have seen an increase amongst evictions, in addition to a lack of maintenance being done within a tenant's respective apartment. So the bill proposes and establishes some of the following rights, of which some of them have already been a part of other bill packages as well, so it might seem a little duplicative, but it's important that within one piece of general law, we're able to define what these Bill of Rights are for renters across our state. So the first one would ensure legal representation through the Public Defender's Office for tenants with children who are facing eviction. Next would underscore the conditions of habitability in accordance with General Law 45-24-36. In addition to protecting a tenant's right to organize in accordance with General Law 34-18-46, establish a first right of refusal for tenants when their home is being put out on the market for sale, with the exception of single-family homes. So this would be first right of refusal as it relates to multifamily homes, and the idea would be that if the respective property owner is going to sell it, that they would provide identical terms as it relates to the cost and the value of the home when selling it to the respective tenant. Next would prohibit the discrimination in the showing, leasing, or renting of properties based on numerous characteristics such as sexual orientation, gender identity, age, or disability, some of which has already been codified through the Civil Rights Act, but again, it's still important to be able to further codify it within state law. Next would require annual leases unless the tenant waives that right in favor of a shorter lease that is not 12 months. Establish a 4% cap on annual increases through the means of rent stabilization. So in other words, ensuring that we are not seeing outrageous rent hikes, but instead ensuring that on an annual basis, the maximum increase to one's respective rent would be no more than 4%. And then lastly, establish a requirement to run pest inspections and mitigate pests, including but not limited to bed bugs, cockroaches, termites, and fleas. Thank you.
So I'm going to be talking about H 5899. The goal of this bill is to help prevent tenants of long-term rental units from being unknowingly exposed to radon gas. So radon is an odorless, colorless, hazardous gas that can cause lung cancer. It comes from the natural decay of uranium found in soil, rocks, and water, and it can be harmful when it seeps into homes and other buildings. According to the Rhode Island Department of Health, 1 in 4 homes in Rhode Island contains radon, at or above the EPA action level, which is 4 picocuries per liter. This is significantly higher than the national average, which is 1 in 15 homes. The inspiration for drafting this bill was a front-page story that ran in the Projo back in January of 2023. A tenant in a South Kingstown apartment decided to hire a radon inspector to do a radon test, and she found radon levels that far exceeded the EPA's acceptable levels. In this particular example, the average radon level was 24.3 picocuries per liter, and remember the benchmark the EPA says above which is dangerous is 4, so she had 24.3. And the way people talk about radon exposure to make it more tangible in terms of the health risks, that 24.3 picocuries per liter is equivalent to smoking 40 cigarettes per day in terms of your lung cancer risk. This exposure won't kill you immediately, 40 cigarettes a day, think of it in those terms, but over time, that exposure, your risk of lung cancer increases as a result of this exposure to radon. This woman, this tenant, informed her landlord's real estate agent about the high radon levels and was told she could be let out of the lease if she felt that the property was unsafe. The tenant didn't want to be let out of her lease. She would have paid for the mitigation herself, but was told by the manager that nothing should be done to the unit, leaving her with an unfixable, unhealthy problem. As she searched for a new home in a tough rental market, she learned that the landlord had declined to renew her lease and would not allow her to stay until she could find another place to live. So when I looked into this issue, I found that current Rhode Island law lacks protections for tenants when it comes to radon testing and/or mitigation. H 5899 requires landlords to conduct a radon test of residential rental property every 5 years. Short-term residential rentals would be excluded from radon testing requirements, for example, Airbnbs, short-term rentals. The bill tasks the Rhode Island Department of Health to develop guidance for proper procedures for radon testing and reporting in these units, and the bill includes penalties if the landlords fail to test, falsify results, or withhold results from tenants or applicants. If the landlord's test indicates a radon hazard, it must be disclosed in writing to the tenant within 30 days. If a mitigation system is in use, that must be disclosed. If the landlord becomes aware that a radon hazard exists, it must be disclosed to tenants and prospective tenants. The Department of Health would be required to maintain an online database to track residential radon hazards, and it would be posted publicly for all prospective tenants and tenants to see on the internet. In order to draft this bill, I worked with my counterpart in the Senate, Senator Burke, and I also consulted with experts from the Rhode Island Department of Health. There are 4 other states that require landlords to disclose radon levels to renters, and this bill would help raise radon risk awareness to tenants. It's important to note that this bill does not go as far as mandating remediation. But I'm hopeful that landlords will do the right thing and remediate where needed in order to mitigate harm to their tenants. And I believe you'll see some written testimony indicating that they don't think this bill goes far enough to protect people. I'm guessing you're going to hear tonight from people that feel that this bill will create a hardship for landlords. Again, this bill does not mandate remediation. It's testing and disclosure. The ball is really in the landlord's court. If they know their property has an elevated radon exposure, their tenants will also know it. And I view lung cancer as a hardship. So I feel that it's a good bill, and I hope you'll consider it.
Thank you, Chairman Craven. 6197 was suggested to me by the Rhode Island Human Rights Commission. It makes some changes to our Fair Housing Practices Act. It in part bringing it in line with the Federal Fair Housing Act regarding companion animals, and changing to that from seeing eye dogs, and also puts in place protection as regards housing status, as one can't be discriminated against for housing, perhaps because they're homeless. It's lots of pages, but very little change in the law. And as I said, suggested by the Human Rights Commission.
So this bill is about access, a right of access to legal counsel for all tenants who face an eviction and who cannot afford an attorney, and notice of that right. Currently, I do want, in its current form, it notes the Public Defender's Office, although this bill is a working draft, and to hear from others, because we know Rhode Island Legal Services here in Rhode Island is currently the civil arm for eviction cases here in Rhode Island. So with that said, just keep that in mind as we're going through this bill, but really about the need for a right to counsel here in Rhode Island for people facing evictions. And I do want to add to, I've witnessed firsthand the insurmountable task of Rhode Island Legal Services there at the help desk. I remember a time before the help desks were there, and the hopelessness of people when they faced eviction. Running around pro se to try to figure out what that process is, trying to learn what a pauper's form is, trying to learn what a stay of motion is as somebody facing those evictions. These are things that attorneys, that, someone who's taught and learned in these procedures, not, individuals who are tenants, especially for something so important, so detrimental to someone's health and well-being as housing, when it means homelessness for a mother, a child, a family, when it comes to the result of an eviction case. So really, this is about that. I did want to add that there's some sort of right to counsel in the country in 16 states and 15 cities. Even before COVID, there were over 3.6 million evictions filed every year, demonstrating the system has been in crisis for some time. We know it here in Rhode Island, and the stakes are severe because tenants who have been evicted don't just lose their immediate housing, but then also what they lose in mental, physical health, and then the child custody, I've seen it, employment, education, and so many other things, as well as their physical property. I do want to add that Oklahoma did some research with the Open Justice Oklahoma Fund, that tenant legal representation increased the odds of unit retention by 75%. In Massachusetts, they found that low-income tenants who had a right to counsel, 90% of those cases that result in positive outcomes, and 70% were able to remain in their housing. So this is part of our housing crisis, when we see it every day at that eviction court, and when people go forth without legal representation. I won't go through every single state, but many more states that show that have these positive outcomes when people are represented in these types of proceedings. So overall, a financial analysis company that has produced extensive right to counsel reports for numerous cities has consistently found that a right to counsel leads to more than 90% of tenants avoiding disruptive placement. And we know we saw similar results here in Rhode Island, especially when we saw the work of Rhode Island Legal Services and the Help Desk, the Center for Justice, and many other groups who stepped up to help with this crisis and help to stop homelessness in our state. So that's my introduction. Thank you.
Vice Chair, sponsors, and members of the committee, good afternoon, and thank you for the opportunity to speak. I am testifying in my capacity as Chief of the Civil Division of the Office of Attorney General on Bills 6201, 6238, 6239, the lead bills. I'd like to take just a few moments and then turn over the rest of my time on behalf of the Attorney General's office to the state's civil rights advocate, to my left, Keith Hoffman. When I became chief of the Civil Division 3 years ago, I was given the mandate by the Attorney General to use every tool at our disposal to improve the lives of Rhode Islanders. As you may have heard, we've been rather busy. When it comes to children, we simply began by simply enforcing existing laws that require lead-safe home in partnership with our colleagues at the Department of Health and in the community. I think we can all agree that it is wrong to illegally offer to and then collect rent from a family when the home being rented has not met the legal standard for lead safe, when that home is poisoning the children who live there. Through the hard work of our team, approximately 50 homes have been and are being made safe. These are properties rented by landlords operating illegally, without mandated lead certificates, falling beneath lead safety measures, resulting in the poisoning of children. But our work relies on circuitous processes, and children need a straighter path, and that's what these bills provide. The bills before you are light touch regulation with no new lead hazard mitigation requirements. They're designed to make sure landlords follow lead poisoning prevention laws that have been on the books for 20 years. We need housing. We are in the state with the lowest increase in housing per capita and the second highest increase in homelessness, according to the report released yesterday by the Rhode Island Foundation. Building housing is great, and we need to use the housing we have. The bills before you today help us finish the job of ensuring safe housing for children. Before I turn over the rest of my time to our civil rights advocate, Keith Hoffman, I would like to leave you with one thought. There's a reason I put the lead advocate and lead work in our new Civil and Community Rights Unit that is part of our public protection, the Attorney General's Public Protection Bureau. It's the same reason you all have passed laws and myriad legislation protecting civil rights. Because it's the job for all of us in the law to make sure that people in our state have a fair shot, a level playing field at the outset. That requires us to make lead poisoning of children a bad dream, a thing of the past. Thank you.
Thank you, Chairman Craven, and thank you to our sponsors, Deputy Whip Ackerman and Representatives Morales and Dawson. I want to touch briefly in a little bit more detail, and I think why we care about this issue of lead poisoning in this state, and then adding to the detail that the bill sponsors have already testified about, why these bills address the problem. So the reason we care about lead poisoning is that it devastates families in this state, and it continues to. I see this in our work every day. We see children who've been poisoned, their families, their parents are beside themselves, and they live in units that were required to have lead certificates of conformance, but didn't have them as required by law. As Miriam mentioned, as the chief of our civil division, Miriam Weisenbaum just mentioned, we passed laws in 2002 in this state to mandate these certificates of lead conformance for most rental units in the state. And yet we know that there is widespread noncompliance with these laws. Thousands and thousands of units that are required to have them don't. And those are the units where kids get lead poisoned. In the units that have the certificates, it is extremely rare for children to be lead poisoned. That's why this House and the state passed those laws 20 years ago. We passed those laws, and the reason why we still care about this issue, because even low-level lead poisoning has very significant impacts on children. It results in increased criminality, it results in lower IQ, it results in lower test scores in schools, increased healthcare costs. And what that means is there's this cost to society. And so economists at in Rhode Island and also nationally have studied, well, what are the costs to our society from lead poisoning? What they found is that for every dollar, conservatively, for every dollar that you spend on lead poisoning prevention, you yield $17 in future savings. So it is a good investment for this state to invest in lead poisoning prevention, and clearly it is so important for the families that are impacted. Why did we why do we think that these bills address this problem? Well, when we began this work, as Chief Weisenbaum just mentioned, we knew that we were experiencing lead poisoning rates significantly higher than a lot of other states that have this very similar certificate of lead conformance requirement. They differ a little bit from state to state, but the same basic parameters. So why was Rhode Island falling behind? And the answer is because there was non-compliance. And so we looked to the state that is considered the gold standard. If you talk to public health experts, everybody points to Maryland as the state that is doing the best job. And as Representative Morales earlier noted, Maryland has managed to reduce lead poisoning rates between 95 and 99%, depending on the year, from around 2000 by implementing these measures. The bills that you have before you, 6238, 6239, and 6201, are adopted from best practices in other states. Just very briefly, Maryland instituted the rental registry for pre-78 properties in the early 2000s. It's been an incredibly effective tool at ensuring that these certificates are actually obtained by property owners. Right now, we kind of have an honor system. Nobody knows who's supposed to obtain them. Nobody knows where the files, whether their landlord is supposed to have one or not. And it frankly hasn't worked. By requiring the certificates to be on file, you ensure compliance. A lot has happened since Maryland instituted its statewide rental registry, and a lot of other jurisdictions have introduced rental registries, from Boston to Austin to Washington, D.C., Seattle. Rental registries are thought to be good public policy. Obviously, there are many other issues like radon besides lead. And so while this rental registry bill requires pre-78 landlords to file their certificates if they must have them, it does require all landlords to register in the state. As Miriam mentioned, we think that these registration requirements are very light touch. They would take about a minute and would subject property owners who are renting out their apartments to the other kind of common sense public health registration requirements that like hot dog vendors and secondhand furniture dealers and all sorts of other folks doing business in the state already have to comply with. Second, the escrow bill. This, as Representative Morales mentioned, is a bill that fundamentally is about encouraging compliance when there is a lead hazard violation. Why should a tenant be forced to live in these very unsafe conditions while the landlord continues to collect rent? But importantly, the landlord will be able to collect rent once they come into compliance. What we have now is a situation where a lot of tenants withhold rent and then they're sued for eviction. That is not the way to resolve this problem. It's to get court intervention. And that, again, is a tool that Maryland relies on very effectively. Finally, the treble damages provision is adapted from Massachusetts, Pennsylvania, and some federal law related to housing and lead. This is slightly different, but the basic idea is that many jurisdictions use treble damages to ensure that there's compliance with laws when there's kind of a history of law breaking in a certain area, and to ensure that victims are fairly compensated when a tragedy occurs. Of course, happy to answer any questions that any representative may have.
Thank you, Chairman, members of the committee. My name is Matthew Toro, and I'm the acting public defender. Actually, on Thursday, Colin Geiselman should be getting his hearing before the Senate Judiciary Committee, so hopefully my tenure will be coming to a close soon. But in the meantime, I have submitted written testimony on H. Bill 6129 with attachments, and I've recently been in touch with Representative Cruz as well as the Rhode Island Center of Justice addressing some of our concerns. So I will be brief, but I do think it's important to note as far as 6129 impacts this office, that impacts our office, that we should be on record. The Office of the public defender is supportive of this legislation and in concept. And eviction proceedings and displacement because of evictions have a disparate impact on low-income individuals. Low-income individuals represent 100% of our clientele of people who are charged with criminal offenses. Representation of low-income individuals who are at risk of losing their home in legal proceedings preserves access to housing and ensures compliance with the laws governing landlords and tenants alike. And that's why we are supportive of this legislation in concept. However, we have serious concerns as it's currently drafted. The Office of Public Defender has a well-documented caseload crisis here in Rhode Island, and it's been that way for some time. Several years ago, actually about 2 decades ago, the American Bar Association's Standing Committee on Legal, Indigent, and Defense instituted caseload caps, so the theory behind it was in public defender systems, these are caseload caps that should be assigned to each attorney, and each attorney should not be assigned more than this number of cases. And the theory is cases in excess of those caps would be a proxy measure of an overburdened system, and perhaps our constitutional mandate of zealous, prepared representation was not being met. Well, so in the misdemeanor division, they assigned those the cap numbers were 400 misdemeanor assignments per lawyer per year. In FY22, based on our FTE staffing levels, we should have assigned 3,500 cases to our misdemeanor staff. We actually assigned 8,417 cases to our misdemeanor staff. It's almost 2.5 times more than what the ABA's ethical caseload limits were. There is absolutely no way the Public Defender's Office, as it's currently funded, would be able to handle the influx of civil cases that 6129 contemplates. To demonstrate that point even further, actually just in 2017, and I did include it as an attachment to our written testimony, the American Bar Association came back into Rhode Island again, and they actually funded a grant-funded study. Instead of looking at caseload caps, what they did was they used the Delphi method, which is using best practices of attorneys' time on cases and case types. And what they used with the accountant firm Blum Shapiro is use that Delphi method to identify how much time an attorney should spend on average in any type of case. And after a thorough evaluation of all of our case types, from appeals to misdemeanors to juvenile to felony, the report concluded that the Office of Public Defender was deficient by some 87 lawyers. So no matter how you look at it, whether you want to use the hard caseload caps or the Delphi method of prevailing professional norms, we are woefully underfunded to handle the criminal cases that we have right now. We would not be able to absorb the case types or the case numbers that this bill would contemplate. Now, like I said at the beginning, we are supportive of this, and we will be working with Representative Cruz and Rhode Island Center of Justice to offer whatever input or assistance that we can give in terms of changing that legislation. But it is our opinion that the most appropriate place of those systems, of those cases, would be, if this would pass, would be to either a standalone agency that could absorb those cases in and of themselves, that focused in on landlord-tenant cases so they could be up to date on the latest advancements of the law and be concentrated and hold CLEs and inform the whole Rhode Island Bar Association about those advancements, or a commitment and reinvestment in the community providers that are already operating in that space currently, and to divert those cases there. I think that is probably the most cost-effective way of dealing with a very important issue that should be addressed, but as far as it impacts the Public Defender's Office, unfortunately, we would not be able to do that.
Yes.
Thank you, Matt, so much for coming out and obviously, you know, discussing this with me. So thank you for sharing that, because this draft was after a New York model, which they created a public defender, which I'm well aware you're overworked, underfunded, which identifying Rhode Island Legal Services, who is currently the civil arm, and faces dissimilar on the civil side for evictions, where they handle over 100 a month just at that help desk alone. there at the court. So I really appreciate your feedback, because translating that into what we have now existing, where Rhode Island Legal Services and then the Center for Justice and Roger Williams Law Clinic will come in and try to help, that we really need to dedicate some funds to all these under-resourced legal supports for people who can't afford representation in our courts, whether it's criminal or civil, family court, eviction court. So thank you so much for coming out and providing that feedback, and I do look forward to working with you further on this. Thank you.
Thank you, Rep.
Yes, Dave?
If this were to pass, you said you're short roughly 80 lawyers now. How many more would you think you'd need? Just a curiosity question.
That's an excellent question. I don't know the number of, because we don't operate in the civil world, in terms of the numbers of T&Es, or trespass and ejectments, that are filed in the district court each year, but that's certainly something we could look into and see.
And it's also fair to say that as it's currently constituted, the public defender who I deal with regularly, and I've seen you in action many times, and I see how busy your folks are, they're exclusively, with the exception of parental rights in the DCOF side, it's criminal litigation.
Correct, only, correct.
Fair to say that you don't have anyone on staff that has any expertise in landlord-tenant.
No.
And you don't know if, and it's civil cases where criminal cases, I don't want to say they're cut and dry, they all have their own intricacies, but civil cases on occasion, we saw earlier Representative Boylan discuss radon and other things that could be time-consuming. A landlord-tenant case can be somewhat overwhelming. It could get into a serious amount of litigation. Is that a fair statement?
Yes.
You don't go down there often, though, do you?
No.
You have no idea how many cases are down there, do you?
No, that's why I think maybe looking at the community groups or organizations that are already operating in that field, that their learning curve is not going to be as steep as ours in terms of getting up
In
there.
closing, though, in my comments, I understand that we want to get funds for other areas, but you're woefully underfunded. Is that a fair statement?
Yes.
You're 87 lawyers short.
Yes.
I watch your young lawyers walk into courtroom 4E and with 50 files in a day, hoping to talk
not
to
uncommon.
50 different people that all are charged with crimes and each want top-level service. And I know your folks do the best they can, but you're only human.
Great.
All right, thanks.
Thank you.
Right, yeah, and I just want to follow up and underscore, Rhode Island Legal Services, and to people who are watching, do this work and do it very well on the civil side in eviction. They know it. I've watched them quarterback at the end of a hallway and overturn evictions where someone didn't have representation and really save lives. So Rhode Island Legal Services is currently doing this, and again, as this bill was drafted, it was not in the intent of the criminal calendar, but that of of building up the civil side and that support for eviction. But I definitely want people to know, if they don't know, the concept's similar to a public defender and a criminal, that Rhode Island Legal Services is already doing this work, that people can go there. They have a help desk on that floor for evictions, but we, especially myself in my community, am seeing this in crisis levels. I get calls every day, several times a day, where I'm bringing people over there to the help desk and Rhode Island Legal Services to do that work. So I did want to underscore that that was not the intent to do that, and that this is just a working draft. Thank you.
Thank you, Chairman. Matt, I just want to say, how many lawyers did you say you have currently in the
All right. We have 54.
54, of which my son Mickey is one of them, and they are very overworked. That's all I can say. I don't see him, Sundays, he's working all day, so, but, you guys are doing a good job, and I don't know how you could take this on, but it would require, if you need 80 lawyers, how much does that, what's that number come to, do you know?
No, I don't have off the top of
Probably
my head.
a lot,
You're
and if you were to take this on, you would need even more, right?
Correct. At this point, the position that the office has taken in terms of expanding any services that any lawyers that we could get in terms of getting FTEs, we are putting them towards the current caseload crisis and
Right.
not expanding more services.
Well, thank you for all you do, because it's a necessary part of the criminal justice system, and you guys do a great job.
Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Lynette Forey-Menard, and I'm here on behalf of the Rhode Island Association of Realtors. I'll be testifying tonight briefly on three bills, 6238, 6239, and 6062. 6238 is the bill that creates a process that allows tenants to deposit rent in an escrow account if the property is not in compliance with the lead hazard law. While we appreciate what the Attorney General is trying to do regarding safe and healthy homes, we also believe that people have a right to a safe home and sustainable place to call home. At the same time, we're concerned about potential harmful effects that could come to fruition. When a landlord does not receive rent, if they have a mortgage on that property, it becomes more likely that that property can end up being in default and may end up in foreclosure, which creates a whole nother set of problems. Instead, the association would suggest perhaps trying to put together, when we would work with the AG's office, to come up with some type of a program to actually incentivize and help property owners to mitigate the situation. So it's more of a carrot instead of a stick approach. 6239 requires the Rhode Island Department of Health to build and maintain a statewide housing rental registry. This is a bill that I've testified on for a couple years now, I believe. We have the same concerns that we've expressed to you before, one being the question about what is the cost associated with establishing the registry and maintaining it. And then secondly, it's also a concern about putting or exposing sensitive information for property owners. It could be a disincentive for people to rent, which is exactly the opposite of what the Realtor Association has been trying to do in creating more rental units and more housing units. So for those reasons, we would oppose that bill as well. And then finally, 6062, which is much more comprehensive. I'll just go through a couple of items that we wanted to bring up. The first one is the right of first refusal. This bill would allow a tenant 60 days to consider any offer that the seller, the owner, had with another potential buyer. If anybody is involved in selling properties, you know that, one, people want to close quickly, so that does provide a disincentive for someone to buy the property. And secondly, what often happens is that a seller and a potential buyer may change the terms of their agreement as they go along in the process before closing. The way this is drafted, we believe that any change that would be made would create another clock ticking and create another 60-day waiting period. Another section of this bill creates a protected class for individuals that are not employed and that have a low credit score, or perhaps not an appealing credit score for a landlord. That is a tremendous benefit to individuals. We're actually looking at unemployment as the same as race and religion and marital status, and we think there is a difference. Third, this bill holds landlords to the 4% rate of increase of the rent unless they can articulate evidence, which is not defined in here. So what may be an articulable, it's a hard word for me to say, evidence, what may be fine for me may not be fine for someone else, and we're going to end up back in court arguing over whether or not it meets the standard. I believe I'll let the rest go with the written testimony, or I think I'll keep you here too long, Chairman, but I'll be happy to answer any questions.
Any questions for the witness? Thank you. Jim, welcome.
Mr. Chair, members of the committee, my name is Jim Vincent. I'm the immediate past president of the NAACP Providence branch, and I'm here as a concerned Rhode Islander. I'm testifying in steadfast and strong support of House Bills 6201, 6238, and 6239. This package of bills will change the course of our state's efforts to eradicate the scourge of childhood lead poisoning. Lead poisoning is a preventable ill that disproportionately afflicts children of color in our state. In addition to the racial equity goals underlying any effort to eradicate childhood lead poisoning, this issue hits a personal chord for me. Throughout the 80s and 90s, I worked as a housing advocate and activist on lead poisoning prevention efforts in Boston and in East Providence. 40 years later, our kids are still tragically lead poisoned all the time, with lifelong impacts on a child's cognitive, emotional, and physical development. But other states, like Maryland, have all but eliminated childhood lead poisoning. Both 40 years ago and today, lead poisoning afflicts every community in the state from East Providence to East Greenwich, a wealthy community where still 1 in every 20 kids are lead poisoned. But the data lay bare that lead poisoning leaves the greatest toll in communities of color. In 2019, kindergartners of color made up over 60% of all students with elevated blood levels, 5 micrograms per deciliter. Urban core communities where the housing stock is overwhelmingly pre-1978 have the highest lead poisoning rates in the state. In Providence, 1 in every 5 elementary school student has been lead poisoned. Many other testifiers today can attest to the devastating impacts of lead poisoning on children's health, education, outcomes, and crime. But as a community activist, I want to emphasize that enacting this package of legislation is a concrete, actionable way to protect our kids from the devastating, lifelong impacts of lead poisoning, and at the same time, level the playing field for our students of color who disproportionately bear the brunt of this scourge's awful burden. Thank you.
Any questions for Jim? Thanks, Jim. Good to see you. Donnie.
Thank you, Chair. My name is the Reverend Dr. Donnie Anderson, a resident of Providence and the chair of the Rhode Island Democratic Women's Caucus. I'm here testifying on behalf of the caucus tonight. I'll be very brief. This is a matter of concern for us because we care about our children. This is one of those issues we can solve. I mean, there are some things facing our kids we can't solve, right? Or it's hard to solve. We can solve this. And we know that what the Attorney General's office is presenting has proof that it works. And on behalf of the caucus, I'm here to say and ask you and just say, the time is now. Let's do this now. Let's save our kids now from the terrible ravages of lead poisoning, and let's move this bill forward. Thank you, Chair.
Any questions for Donnie? Okay, Carol?
Thank you. Next, who signed up for the Center for Justice? Somebody here? Come on up. And Deborah Levy. Is Deborah Levy here? Okay. I'll put her aside. Vincent Green? No? Oh, yeah, there he is. And Melissa Jerusi? Okay, come on up. So if you would state your name, please. Oh, turn your mic on.
Is it working? Okay. Thank you, Chairman and members of the committee. My name is Marielle Garcia, and I'm a staff attorney at the Rhode Island Center for Justice. We have submitted written testimony in support of bill numbers 6239, 6238, 6201, 6062, and 6129. I'll just go through each one of them. In regards to bill number 6239, we support this bill because really, this bill increases transparency amongst tenants and landlords. We represent tenants every single day, and oftentimes tenants don't even know the basic information for their landlords and basic contact information. So this would give them that sort of, if they need to contact the landlord, they could. But also, this protects any tenant that is able to see whether there is a lead certificate in their a home that they might be moving into. As of right now, finding that information out is quite difficult. It's something that they'd have to go to code enforcement for, and this just makes it a lot easier for them to be able to, for a tenant to protect their children when moving into any home or the current home that they're in. And really, this is a basic business requirement for a landlord. A landlord has a business, and businesses need contact information, and it's quite simple for a landlord to have separate contact information for purposes of doing business. In regards to Bill 6238 and Bill 6201, these bills really would give tenants the leverage to get their properties remediated. Like I said, I represent tenants in evictions every single day, and oftentimes we see tenants whose children have been lead poisoned, and they feel like after having their child being lead poisoned, they decide to withhold rent because they've been wronged, and then it leads to an eviction, and then these evictions are on their record forever as of right now for something where they've been wronged, and they want to pay the rent, but they want this to be remediated. It feels very unfair for a tenant to pay rent, meanwhile a landlord maybe isn't doing any of the work and is sort of just sitting there and not doing much. So this gives a tenant a landlord the incentive to get this work done in a reasonable time frame, and really encourages them to do so. In regards to Bill 6062, this, like I said, I represent tenants every single day, and a lot of the issues mentioned in the Tenant Bill of Rights are things that are mentioned every single day with almost every single tenant that we represent, including problems with pest infestation. That's probably one of the most common ones. Almost every single time we speak to a tenant, there is an issue with some type of pest that a landlord has done nothing about and that they don't know what to do with that. And this includes cockroaches and mice, and landlords aren't doing anything about it, and tenants deserve to live in houses that are free of pests. Another issue that I want to point out in this bill is also rent increases. I would say in the past 2 years that I've been at the center, we get multiple calls a day for tenants whose rents have increased and they can no longer afford to live there. And it's drastic increases. It's not $100, it's not $200, it's often $500 or $600, and something that is just no longer feasible. And now a tenant is facing potentially being homeless and not being able to live there, or now facing another eviction because they're not able to make rent the next month. And now this eviction is going to be on the record, and they're not going to be able to find housing because housing is so expensive, but also because they're going to have an eviction on the record forever. And the last one, Bill 6129, the right to counsel, I currently, along with the Rhode Island Legal Services, the center, along with the Rhode Island Legal Services, currently are representing tenants as best as we possibly can whenever they're facing evictions, whether that be because they reach out to us directly, but also, like mentioned previously, at the help desk that is now at the courts. So we strongly support right of access to legal services for all tenants who face evictions and can't afford an attorney, and we really look forward to working with the sponsors and other legal aid providers to really find out what the most efficient approach to this would be. We look forward to working with the sponsors and stakeholders to resolve any issues that may need to be addressed in the future for any of these bills, and thank you for consideration of these bills.
Thank you. Any questions of this witness? Seeing none, Vincent?
Good evening, Mr. Chairman, Vice Chairs, and members of the committee. Good evening, and thank you for the opportunity to testify in support of House Bills 6201, 6238, and 6239. I'm a member of the law firm of Motley Rice, and at the direction of and alongside the Office of the Attorney General, my firm litigated the public nuisance lawsuit against the lead pigment industry on behalf of the state of Rhode Island. More importantly, I represent individual lead-poisoned children throughout Rhode Island. In fact, I began representing lead-poisoned children in Rhode Island and throughout the country in 1998. And I'm still doing that today. My office has represented lead-poisoned children in Rhode Island for more than 30 years. I am the person of last resort. I'm the person to whom parents come when their children have been lead poisoned, when prevention has failed, and when there is nothing that can be done but to hold someone to account. Through my work, I have seen the severe and permanent injuries caused by lead. I've reviewed the neuropsychological evaluations of hundreds of lead-poisoned children in the state of Rhode Island. I want to talk a little bit about the science of lead and why we're here. Lead is not like iron or zinc. It should not be present in blood at any level. It serves no beneficial role in the human body, and it is particularly harmful to children. In children under the age of 6, it only serves to cause injury and rob children of their potential. There is no known safe level of lead in blood for children. Even minimal levels below 10 or even 5 micrograms per deciliter, cause cognitive damage. Lead is a neurotoxin. That means when it reaches the brain, it poisons it. It gets to the brain because red blood cells mistake it for iron. They bind to lead and carry it to the brain, which passes right through the blood-brain barrier. Once in the brain, it destroys neurons, the specialized brain cells vital for cognition. But perhaps more importantly, it destroys and limits what's known as dendritic development. Dendrites are the branches or the connections between neurons. They are what allow for communication between neurons and allow our brains to function properly. Lead destroys those dendrites as they are developing in children, and they do not redevelop. The tragedy of lead poisoning is that when children's brains are most vulnerable to this attack is the exact moment when they're exploring their environment through natural crawling and normal hand-to-mouth activity, which is how lead is introduced to the bloodstream. Increased blood lead levels are linked to developmental delays, aggressive behavior, and school suspensions. Lead-poisoned children suffer decreased IQs, and at even the lowest levels, from 0 to 10 micrograms per deciliter, there's a 5.8 point decline in IQ. Between 0 and 25 blood lead levels, there's a total of a 10 to 11 point decline in IQ. After 25, for each 10 microgram per deciliter of lead in blood, each additional 10 microgram per deciliter of lead in blood, there's an additional 2 to 4 point decline in IQ. But because lead can affect all areas of the developing brain, IQ is only part of the story. The impact of lead on cognition is global. It results in lowered impulse control, verbal and visual spatial processing deficits, and attention deficit disorders. Lead-poisoned children have difficulties organizing actions, decisions, and behaviors known as executive function. They also suffer from abnormal social behavior, including aggression. Lead causes gross and fine motor skill deficits, and while it's a neurotoxin, its impact is not limited to the central nervous system. Childhood lead exposures can lead to heart disease, high blood pressure, and kidney disease. Lead poisoning is also a dose-response disease. All of the impacts are cumulative, meaning that the higher the blood lead level and the longer the poisoning persists, the more dramatic the consequences are. In fact, at its highest exposures, that neurotoxin can kill. In children, acute exposures leading to very high blood lead levels in excess of 70 micrograms per deciliter may produce encephalopathy, which is brain swelling, coma, convulsion, and ultimately death. That means that every housing unit in the state of Rhode Island that contains lead has the capability to cause all of the injuries that I've described, including death. Lead poisoning leads to poor school performance. Virtually every lead poison client I've ever represented either had or required and should have had an IEP, an individual education plan. The literature and my experience show that lead-poisoned children not only begin their educational journey behind their non-poisoned peers, but they fall further behind as they progress through middle school and high school. That's because the effects of lead poisoning are long-lasting, they're permanent, they persist into adulthood, and last for a lifetime. There is no cure once the injury is caused. And that's the reason so many lead-poisoned children do not complete high school. But the impact upon individuals and their families do not end with truncated education. The devastating toll of lead poisoning does not end with an affected child or their family, but worsens inequities in our education, healthcare, and criminal justice systems, leaving no corner of our state unaffected. Collectively, these individual stories combine to create an exceptional cost to society at large. The scientific literature concerning it is clear that the cognitive injuries caused by lead, including decreased IQ and loss of impulse control, lead to juvenile delinquency and adult incarceration. The true tragedy of all of this is that lead poisoning is entirely preventable. The CDC said 30 years ago that lead is one of the most common pediatric and preventable health problems facing children today. And that fact has not changed for Rhode Island's children in the 30 years since the CDC made that statement. As destructive as lead is on individuals and society, prevention efforts can be equally as rewarding. Mr. Hoffman mentioned this in his testimony.
Mr. Green, could you try and wrap it up? Because you have a lot of people that are behind you still wanting to testify.
Absolutely.
Your testimony is great, but it's a little long. You've got that whole book in front of you.
So, I just
And if you want to send in anything, we'll read it.
I will happily supplement this in.
Okay.
But I want to say, these bills, adopting a registry, allowing tenants to place their rent in escrow, and to provide double and treble damages and attorney's fees when victims, to adequately compensate victims, will improve compliance in Rhode Island without placing any unnecessary burdens on landlords already in compliance. Prevention is the key, and each one of these provisions will do that in spades. I want to thank the sponsors, and I want to give my appreciation to the Attorney General's office for taking this issue on. Thank you.
Thank you very much. Any questions? Representative Cruz.
I just wanted to make a comment. I just wanted to thank the AG's office. I know as a mom who my youngest child was lead poisoned 23 years ago, and that heartache of getting that call from the blood work, barely 1 year old, severely lead poisoned, and then comes the trauma. Watching your child hooked to all kinds of tubes, get in the collision as your child's crying, wishing they could come out of this steel metal crib. To get this poison out of their body, not to mention what they use also has its own side effects. And many of the things you said, he lived with it today, he had an IEP, he had all those things going out through school. And not to mention, this was in the northern part of the state, but then my nephew in the southern part of the state was also lead poisoned, but more severely so, and living with some really debilitating life issues. So I just want to thank you for bringing this forth in the AG's office, for taking on this crusade and making sure we prevent this from happening to another child.
Thank you. Yeah, the time has come to prevent lead poisoning. It shouldn't be happening anymore. Thank you for your testimony. Next, Melissa.
Good evening, Chair and committee. It's my first time, so a little nervous.
Welcome.
My name is Melissa Grucey. I'm actually a real tenant of West Warwick that I am here to support and testify with 6239, 6238, 6201, and support of 6129. So together with these bills, it will reduce the exposure of lead poisoning in the children. I don't know if you guys have watched the news. I've actually been in the Providence Journal with what's going on with my landlord. And what I brought is, this is what falls off my walls every day, and this has lead. I have a 4-year-old. My 4-year-old has an IEP. I have a 12-year-old that has an IEP. I was pregnant during the time of moving into the apartment. I never got a certificate. I was just told it's okay. I never got anything else. I ended up getting pregnant, and my daughter goes to doctor daycare. She has behavioral issues. It is affecting her. I am waiting for confirmation of the lead testing, but the teachers are already seeing developmental problems with my daughter. She doesn't speak fully. She struggled with walking, and I have to literally live in fear of this right here falling off every day, and I have to clean it up. This is from a bathroom I have to give my daughter a tubby in. and nothing gets done. We need to reduce the exposure. And I've worked in mental health, in psych wards. This affects them as adults also. It's not just our children, but when the adults also deal with this. This is a stigma that causes them to have dual diagnosis that goes untreated and given other things. I also have a fellow tenant named Chris Valquez. I might have said that wrong, I'm sorry. He couldn't make it this evening, he's actually at work. He sent you guys a really great letter in support of these bills, especially lead. His children were poisoned, and it's confirmed. Not only is there going to be an economic struggle for them, financial, and again, I have been a very big public speaker of mental health during our housing crisis. Do you know what that does to a family? That can make or break a family. I'm going through that myself. Now, when it comes to the public defenders, we really need a section, because when I went there, I was 7 days late on rent. 7 days out of 5 years. He literally put an eviction, all because I've called code at West Warwick, and my house has failed 4 times, repeatedly, for the same things. Water, rats, holes. If you go online on Uprise, Rhode Island, there's a whole video of my whole house. I laid it bare for the public to see what really is going on. I do pay my rent. I pay $19.50. I pay my rent. I've only been late once, and it got taken care of throughout the now 6 years I've lived there. Okay? And now I have retaliation being done by my own landlord. But we really need to get this lead situation really under control. It's affecting our children. It's scary. You have parents out there not knowing if a house is even safe. The registry of knowing, and it needs to be user-friendly. I have gone on your guys' websites, and I am so confused and overloaded, it makes me have ADHD just looking. I need like 10 different screens just to get to one thing. It needs to be easy, user-friendly, public accessible. I'm not asking for all your information. I don't want the landlord's social. I just want to make sure that apartment I'm looking at is lead-free. And making sure, when it comes to also the evictions, just so you know, I have an eviction on my record. Never going to go anywhere. And because of what's happening right now, being public about everything, I've had now 6 landlords tell me they will not rent to me because I've made too much noise. How is that fair? As a Rhode Islander, I was born here, and I can't even now get a new rental because I spoke up, because I called code myself in order to get help. And that is why I became part of Reclaim Rhode Island, to help stand up for other people, to help advocate and help direct them to where we can get some help, and kind of ask you guys, please look what's happening in your communities. Your community's scared. You guys need to go out there and talk to them. They are actually scared of you guys because they don't feel like they're going to be listened to. They're going to be looked down on because maybe their houses aren't perfect. You go on that video, my house isn't perfect. It's lived in by 3 children and a single mom. I'm doing the best I can, and that's how a lot of families are. They really want to talk to you guys and let you guys know what's going on, but they're scared. And with the lead paint, and they're getting evicted, we really got to do something.
Thank you for your testimony and your personal story. Any questions? Hearing none, we'll go to the next 3. But believe me, we heard you. We're listening, all 3 of you. Jonathan Womer and Katie West and Jeremy Costa. And everybody, we still have a good amount of people. If you could keep it to as short as possible, whatever that might be, 5 minutes, 3 minutes, it would be appreciated so we can get through everyone. Okay, Jonathan, you want to start?
Thank you, Chair, members of the committee. I'm glad to be here. I'm Jonathan Womer, a member of the Policy Lab at Brown University, although I'm not here on behalf of Brown University, and former proud state employee. I'd like to do two things. I'd like to highlight a couple of studies that I think make this issue a little clearer, and then talk about some of the ways that maybe we can go about this. I'm here to speak in favor of the lead protection bills that are on the agenda for today. So the first is a study that researchers put together very, very recently in November. It's probably the latest lead study, gathering data from over 500 data sets across the world, looking at the connection between lead and crime rates. And to summarize it very, very briefly, if lead is mitigated, you can see up to a 15% reduction in the homicide rate. If you want to reduce violent crime, mitigate lead. The second is a study that Brown and Princeton researchers put together in 2019 using data from Rhode Island preschool children. It's one of the first complete longitudinal studies that track kids over time. We can all be very, very proud that Rhode Island keeps very, very good track of longitudinal data of its kids. We could maybe not be as proud about the lead in Rhode Island. They found that a kid that suffered lead poisoning has a much substantially higher probability of very, very low test scores in math and reading. You want to raise test scores in Rhode Island, mitigate lead. Lastly, I'd like to talk about some of the just general objections to these bills and other work in lead. This is a one-time issue. Once you fix it, you've generally fixed it once. And the Biden administration has made it very, very clear in the last couple of years that the $1 billion that it has given the state of Rhode Island and many states can be used for mitigation of lead paint and lead pipes. Now, I realize that the cost issue is outside the purview of the committee and the bills before us today. But as we're looking at the objections to these sort of bills in the end of the legislative session, I think it's worth knowing that we do have a lot of federal money that the federal government has made very clear we can use to help with this issue. Thank you for your time.
Thank you very much. Katie?
Good evening, Madam Chair, members of the committee. Thank you for the opportunity to speak tonight. My name is Katie West. I'm the Director of Strategic Initiatives at the Housing Network of Rhode Island. We're the state's trade association of 15 nonprofit community development organizations. We also have a coalition of 80 organizations called Homes RI that support increasing the supply and access to safe, healthy, and affordable homes. And I am speaking tonight on 3 bills essential to preventing lead poisoning and improving access to quality housing, 6239, 6238, and 6201. We also submitted written testimony on this package of bills. I also just want to say for the record, we also are supporting 6062, 6129, and 6197 with written, but I'm going to focus my remarks on the lead bills. And I will be brief, try not to be repetitive. But we know that Rhode Island has some of the oldest housing stock in the country, third in fact, with 72% of homes being built before 1980. And as Mr. Vincent spoke about, this housing, a lot of it's concentrated in our core city, so there's that disparate impact on kids in those areas, but it is a statewide issue. Kids living, testing positive for elevated blood lead levels. You've heard really powerful testimony about the impact, the negative impacts of that, and it's devastating, not just immediately, but later in life for children, families, and whole communities. And so this package of bills just helps address gaps in the enforcement and compliance. You heard that from the Attorney General's office staff, Mr. Hoffman. I want to talk a little bit just briefly about H6239 in particular, which is the rental registry bill. So this would establish a registry and ensure landlords follow existing laws related to lead hazard mitigation. Also would have the following benefits if implemented. It's an important consumer protection bill, facilitates compliance with health and safety standards, of course, but also could help with the potential distribution of information relating to housing quality among landlords and tenants. And having a repository of information, we've talked about this before, about rental properties can really help provide policymakers with better information about the quantity, availability, age, and condition of our rental housing stock. That's something we know is imperative given sort of the state's charge related to housing planning and administration. Recent report that was released on housing and homelessness in Rhode Island. So with that, I want to thank the bill sponsors, thank the Attorney General, their staff and their team for their leadership and your leadership on this issue, and the community advocates that have informed the legislation, and strongly urge the committee to pass these bills. Thank you.
Thank you, Katie. Jeremy?
Yeah, good afternoon. I appreciate you allowing me the opportunity to speak in front of this Judiciary Committee. As you know, I speak amongst and for myself and for the community that I represent, that being the disenfranchised, those that might have been formerly incarcerated, and those that have been left without access. So considering the access, I want to first talk about Bill 6129, which is a right to counsel. I think that the Public Defender Office gave you guys enough information for you guys to understand that each and every person that steps in that courtroom has actually been awarded ineffective rule of counsel for being an inmate or being a person that is being charged for an offense, because they are 87 public defenders short. 70 to 90% of the inmates are indigent and don't have the funds to be able to pay for a lawyer. So anybody that is got a caseload that is more than 400 is overloaded, overworked, they're just understaffed. So clearly there needs to be a new division that needs to be established. And I don't think it needs to come from the Public Defender's Office. I think that it needs to come from the housing budget. You put $250 million into this budget, and you use 20% of it to advertise with your media companies that are helping you gain whatever, voter confidence or whatever in your current spill you got going on here with this housing. $250 million was put into a housing department. $10 million was put into a coffer for homelessness for an immediate, but you could have used that same money and put it into a fund that was going to fund lawyers for those that were going through the adjudication or eviction process. So I think we need to focus on those that are being afflicted, that are currently in the circumstances, not so much on these media companies that are looking for advertisement dollars and waiting for you guys to create a new committee so you can create advertisement dollars to fund them. We need to focus on those that have been afflicted. If you focus on those, you're going to get a more productive society. The second thing that I want to discuss is not only every person that comes in front of a judge in regards to an eviction process indigent. Not only are the Constitution states that anyone that is in front of a court of law should be awarded the right to counsel. The Constitution states that. So we need to start standing up to the Constitution before we administer our laws. We need to look at the constitutionality of that law to make sure that it doesn't infringe on anyone's constitutional rights. So that's an important thing. So that needs to happen. The other thing is I wanted to talk about this lead poison. You probably are wondering why I'm sitting here testifying in regards to some of these public health issues, because I am a product of lead poison. I am also a product of your state custody services or state custody services. So, for instance, the services that you provide individuals that have gone through your system, I am a product of that. So when I'm coming up here and speaking to you and I'm giving you testimonies, because I experienced the torture through the state custody systems that you guys provide. I have also been if you want to say, client of your ineffective rule of counsel. I've also been an indigent defendant and not awarded the proper, if you want to say, counsel in regards to my case. So it's very important when I speak that you guys listen, because I'm a product of the state's custody. You created this monster.
Well, can you get to the bills that you're
Now, let's
supporting, please?
Now, so I just want to get that clarity. Yes, the bill that I want to discuss.
Want to talk about the bills that are before us
The bill that I want to
tonight.
discuss is a lead poison bill. Not only should you have an escrow account, but there should be a betterment agreement. You have all this money that's been allocated to the state. There should be betterment agreements, because everybody doesn't have the money to be able to fix their home. There are homeowners that are just, maybe renting out a house, renting out an apartment. So there needs to be some type of agreement. There needs to be some type of mechanism that is set up for those homeowners that are going through, or that might have just purchased this home, and didn't get the disclosures from their real estate agent, or the proper disclosures. So they're absorbing and accepting this home, not knowing that there's lead poison in it. So we need to set up some type of betterment agreements with the homeowners, not so much look for punishing the homeowner, because many of these homeowners are not aware of the lead that's in the house in itself. And for the other thing, in regards to your, in regards to the ineffective rule of counsel, there needs to be a mechanism where you guys are drawing from the third year college students at Roger Williams, or maybe you should open up law programs in other schools, maybe Brown, maybe Rick, maybe Rhode Island College or Roger Williams College shouldn't be the only place where you pull your law clerks and your people from. And maybe they should be awarded a stipend or something. Those third year students, those third semester students should be awarded an opportunity to defend some of those people. That's what happened in North Carolina, and you'll see if you study what happened in North Carolina, they were able to help about 70% more of those people going through the conviction, because they were able to use their college graduates or people that were in law school to create if you want to say, an agency that was helping those that are afflicted or that were going through, because they didn't have the budget in their state budget to allocate, 87 more plus an additional, 20 to 30 more people in regards to the civil eviction courts. So that was another idea that I think should be looked into.
That's a good idea. And, they already do it in the AG's office and the public defenders with the Rule 9, that they call them attorneys. So they come out their final year of law school and they can actually work with both those departments. But I think that's a good idea.
Absolutely not. Absolutely not. There's one more bill, and it's in regards to the Bill of Rights. The Bill of Rights, I don't know if it goes too, I don't know if it goes deep enough. I don't know if people understand. So let's just put it this way. There needs to be a victim witness fund for those that are going through, let me just get rid of them, that are going through lead poison. There not only should be an escrow for those tenants, there should be a victim witness, because years of lead poisoning can cause years of financial crises. Years of lead poisoning can cause years of scatteredness, impulsiveness, years of, distractions and disturbances. So there should be some type of victim witness fund for those that are going through lead mediation, or anybody that has been adjudicated. $5,000 fine, he doesn't have to pay that. He doesn't have to pay that immediately, He just won't be given building permits. So there needs to be some type of law that's set up to where, money that is gone into this goes into this victim witness fund, and those people that are victims of lead poison are recipients of this. And
Well, very good, Jeremy.
Yeah.
Thank you very much.
and I just wanted to make sure I'm just touching everything, so.
But we got more witnesses, and
Wonderful.
you've
Wonderful.
used quite a bit of time, so
Yeah.
thank you very much.
Yeah. All right. Yeah.
All right,
Well,
we're going to call the next three witnesses.
All right, thank you.
Thank you. Vivian Sutherland, Lauren Hill Richer, David Vetz? I can't really read it.
I have really bad handwriting.
What? You have really bad handwriting? Okay, Vivian, or who's ready?
I'm ready. I'm Vivian.
Okay, Vivian.
Hi. So thank you for having this hearing on these bills. Thank you, the sponsors of these bills, and everyone else. I already submitted a bunch of written testimony, which y'all can read. So I'm here mostly on behalf of my friend, Tiara Graham, who, she found out, a while back, earlier this year, that her child was lead poisoned. Her landlord wants to flip the house. He's a house flipper. He was part of the Providence Apartment Association at one time. He kept on saying that, my business is FixProv or whatever, Providence Apartments LLC. And long story short, he never gave her proper notice, 42 hours notice, 2 days notice of entering her home to renovate both her bathroom and her kitchen, and the lead paint that was removed during that time poisoned her child. Providence Code Enforcement is already on their second violation with him. He's supposed to fix things by, Friday, and it's not looking like he's gonna. And she's just really upset. She's really mad. It's maybe not enough for the AG necessarily step in, but as we heard from the lawyer earlier and a bunch of other people, it could still have long-lasting effects. I might actually, refer her to that lawyer. But she came to a group of us who really care about tenants' rights, looking for answers, looking for what to do. And so I just wanted to speak her truth. I mean, of course, there's all these other things that she's dealing with too. The habitability. She should have a right to real habitability. There's plenty of other issues. She has mushrooms growing out of the corners of her floors. She has, leaks everywhere, plumbing issues, black mold, things growing under her sinks. It's just really terrible in her situation. And, he's not, compliant, of course, either with the lead mitigation certificate. So a big thing too, for a lot of these, a lot of landlords have multiple shell LLC companies to keep themselves safe because they don't want tenants finding out who they are. That's why they even come here and tell everyone, oh, well, we're worried about these safety issues or things like that. It's not necessarily about we want to know where your house address is or something like that, but we need to know if we even want to organize to fight for our rights, to be able to meet your other tenants. And to be able to actually, because they probably are having the same problems too. And if we're ever going to be able to organize a strong, tenants movement, we need to know, just who also has my landlord. And so I really support the lead registry bill. I've also I live in Federal Hill, and I live right down the street from the Childhood Lead Action Project. And I've, volunteered with them to go and let people know, especially a lot of landlords in my neighborhood, hey, the city knows that you're not compliant, and you might get in trouble. And they don't care. They've yelled at us and told us that we're, words that I'm not going to mention here, and that we're making, trouble for them. And we're just trying to be we're trying to help you out. You could avoid civil penalties and things like that. So it's just a really big issue, and so I really urge you to consider supporting the Tenant Bill of Rights. I think there's many great things in there, especially things around good cause eviction. A lot of like regular like middle class, tenants in like my neighborhood in Federal Hill are getting displaced from the neighborhood. Like I work at a restaurant in Federal Hill. Everyone loves the Federal Hill restaurants, but me and my coworkers can barely afford to live in the neighborhood anymore because landlords will just send you a termination of tenancy notice because you can't afford the rent, or they know or suspect that you won't be able to afford the rent that they want to increase it to because they think, oh, maybe we can move in some young professionals from California or Massachusetts or New York or something like that. And so we should be able to stop that type of thing from happening. We should be able to stabilize rents. We're not seeing like these like small increases of like 10% a year. Like I've seen good landlords talk about how 10% a year is like what them as a reasonable person maybe expect in this type of economy. But what we're really seeing is people coming to our organizing spaces when we're talking to our neighbors saying, oh, I just got, like the other person was saying, from Center for Justice, they talk to them even more than us. All these people calling them every day. And yeah, they're getting $500 increases, $600 increases, stuff that's just insane. I'm sure Jennifer Wood could attest to that.
Well, thank you. Thank you, Vivian.
And that's all I got to say. Yeah, thank you.
Thank you very much. Lauren?
Mr. Chairman and members of the committee, my name is Lauren Hill, and I'm the Chief Legal Counsel for the Rhode Island Commission for Human Rights. And I'm here in support of 6197 that makes some conforming changes to the Fair Housing Practices Act. And I want to say thank you to Representative Agello, who worked with us to get this introduced. Just to add some context for the requests that the Commission has made, first, this would add discrimination on the basis of housing status just to the unlawful practices section. It's already in the Fair Housing Practices Act in some sections, but not in the section about what are unlawful practices. So as a result, we've had respondents and parties push back on the Commission's enforcement of discrimination on that basis. So this would simply make it clear that the Commission has enforcement authority over cases where there's alleged discrimination on the basis of whether a person is housed or not. It also additionally would remove a small section of the bill, or I'm sorry, of the act that was declared unconstitutional several years ago. The provision prevented parties to commission complaints from speaking publicly about their cases, which the court found was unconstitutional. This would merely remove those sections of the act. It also amends a couple of provisions to conform to federal law so that when a person brings a case to the Rhode Island Commission, the relief that they have is substantially equivalent to what they would receive if they were to take a case to HUD. One of those is just to conform some language about discriminatory advertising to make sure it covers the same provisions that the Federal Fair Housing Act does. And then finally, the Fair Housing Practices Act currently uses the term personal assistive animal to mean emotional support animals or service animals, but that term is not defined in the statute, which, as you can imagine, has led to some confusion about what constitutes a personal assistive animal. So this bill introduces the term assistive animal, and it defines it so that it conforms to the federal law. After the representative introduced this bill, we became aware of some concerns from the Governor's Commission on Disabilities about specifically the definitions for an assistive animal. And we immediately reached out to them when we learned of those concerns. I believe they contacted the committee as well to express some of those concerns. We spoke to them, and we have already created a revised version of the bill that would address that addresses the Governor's Commission on Disabilities concerns, as well as still makes the conforming changes that the Commission needs for its enforcement authority. And my understanding is that the Governor's Commission on Disabilities didn't have any objection to the other provisions, merely the definition about service animals. So the revised version includes some clarification on guide dogs and service animals at their request. And so for these reasons, the Commission asks that the committee support this bill and vote to pass. And I can take any questions from the committee.
Thank you. Representative Agello.
Thank you. Just, would you be sure that the committee legal counsel gets a copy of that revision to the service animal definition?
Yes, Representative Agello.
Thank you.
Thank you very much. David?
Thank you, Chair and committee members. My name is David Valise. I'm the director of the Rhode Island Interfaith Coalition to Reduce Poverty, a coalition of faith leaders from many faith traditions all around the state fighting inequality and poverty. I'm also the Environmental Justice Chair of the Sierra Club in Rhode Island. I'll be testifying on behalf of those two organizations. I'm here to support Bills 6239 as well as 6092. Thank you to Rep. Ackerman and Rep. Speakman for sponsoring, and everyone else who has been here advocating for housing. We, like many organizations and advocates, believe that we have a moral obligation to fight housing insecurity. We believe that housing is a human right and that everyone deserves a safe and affordable house, a place to live. Housing insecurity is still on the rise, as is food insecurity and all other things that the pandemic has definitely made worse. When people do have housing, they have to worry about it being safe for their children and for themselves, as you've heard many advocates say tonight. As an environmental justice group, we know that lead poisoning is one of the biggest environmental justice problems in Rhode Island, which disproportionately impacts poor communities and communities of color. We urge this committee to start putting the health of our children and the health of our constituents first. As a faith organization, I will also leave you with this. I won't go over all of the facts of lead poisoning, but I'll leave you with this. I've been thinking a lot about what God's love means when people say God is love. And I truly believe, like many of you, that it is when not only shown God's love through prayers and thoughtful wishes to a community, which I definitely think are important and nice, but it's about action, and it's about passing policy like these policy that really protects people and fights inequality. That's the way that we show God's love. That's the way that we embody what that means to ourselves. So please pass these bills. I think we've been talking about lead poisoning for a long time in this state. We have good laws in place, and now, but it's still something that's preventable that keeps on happening. So please pass these bills and help protect not only for lead poisoning, but for rent stabilization and more bill protections for tenants. I had a lot more to say, but I can't remember it. So thank you very much for listening to my testimony.
Thank you, Reverend, and thank you all three of you. Next, Katie and Maggie. Where'd you go? Oh. Carol O'Donnell, Shanna Crandell. Oh my gosh, you got in. Hey. Is that, Maggie is the little girl? Ah. All right, Katie, you want to start?
Thank you, members of the committee, for being here, for holding this hearing, and for hearing our testimony. My name is Katie Gradowski. This is Maggie. We are here to testify. You want to say hi, babe? Hi. We're here to testify in favor of basically all the housing bills, but in particular 6239, 6238, 6201, as well as the Tenants' Bill of Rights and Rights to Counsel. I am a mom of a child under 6. I am a law student who has worked, volunteered with tenants at the Center for Justice and also with the Eviction Help Desk for the past 2 years. And I'm also a landlord in a pre-1978 building. We purchased our building 4 years ago. It was an old building with many years of deferred maintenance, and we moved in about a month before I became pregnant with this one. And in the past 4 years, we've spent almost all of that time and close to $30,000 out of pocket trying to make our building safe for children under 6. We have not been successful in doing so. Keith Hoffman spoke about lead compliance in Rhode Island feeling like it's the honor system. If you are a landlord in Rhode Island who is trying to comply with the lead laws, in many respects...
Hey, can I do it?
Can you do it? You can in a second, babe. Let me go first, okay? In many respects, compliance feels completely voluntary in a really terrible way. It makes it more expensive to get contractors. It makes it very difficult to figure out what the obligations actually are. And the thing that makes it so hard is that we do not have a culture of compliance in the state of Rhode Island. We don't have a culture in which landlords are generally aware of or necessarily care about compliance with the lead laws. We don't have a culture in which we can rely on inspectors to enforce them or advise on what we should do or where we should find contractors. And it's very hard, even though advocates in the state have taken incredibly valiant efforts to do so, it's very hard to find a certified lead contractor. And when we do find one, because the market by and large doesn't require them to be so, it's more expensive to get those repairs made. The market currently doesn't reflect the fact that our lead laws are in fact mandates, and they don't do it in part... Yeah, babe. They don't do it in part because, we as a state and the legislature and our courts, we don't require them to do so. Maggie, I need the mic. The bills that are in front of you, I need the mic, sweetie. These aren't posing new requirements. They are a baseline for enforcing the requirements that we already have, and they're a baseline for enforcing them so that we can do something about lead before children are poisoned. Yeah. Compliance is the cost of doing business if you're a landlord in Rhode Island. And damages... Baby. Damages for non-compliance... Sweetie, there are a lot of people in the room. Damages for non-compliance should also be the cost of doing business. These regs won't hurt us economically. They'll improve the cost of housing stock. They will help keep children safe, and they will make it easier to be a landlord in Rhode Island. Thank you.
Thank you. Thank you, Katie, and thank you, Maggie. Shayna?
Hi. Good evening, members of the committee.
Is the light red?
No.
Up, button up?
Is that on? Okay. So good evening, members of the committee. My name is Shayna Crandall, and I'm here to represent Reclaim Rhode Island and our strong support for House Bills 6129 and 6062. We also submitted written testimony in support of the lead bills as well as Bill 6197, but today I'm just going to speak about 6062 and 6129. So these two bills would give tenants the right to legal representation in eviction court and enact a tenant bill of rights that would stabilize soaring rents, free tenants from insect infestations in their homes, and prevent cruel and unnecessary evictions. For the last year, we've been organizing with some of the most precarious tenants in the state, all of whom rent from the same monstrously negligent and greedy landlord. More than one tenant from this landlord has described cockroaches crawling on their children's beds at night. So I would like to describe a pattern that I've seen again and again doing this work. So you may not be a renter yourself, but I'm going to use the second person here to describe this pattern. So you move into an apartment in a desperate or near desperate situation. The place isn't great, but you've already been denied for other apartments and your family needs to go somewhere. Maybe things are okay for the first few months, but then things start to break and leak. Your kids start getting sick from the mold in the walls. And you've learned that management is simply never going to fix anything. Then the landlord jacks the rent. You moved in at $1,000 a month, and 3 years later, you're spending, the rent is doubled. The apartment's falling apart. You're worried about poisonous lead as the paint peels off the walls. Not a thing has been fixed, but now you can barely afford the rent. Maybe you get a third job and barely keep up with the doubled rent. Someone gets sick or loses a job, and now you're in eviction court. Without a lawyer, you won't even get a chance to show the court the terrible conditions that your children have been forced to live in. The slick lawyer your landlord has cuts you a terrible deal knowing that you have nowhere else to go. Or after months or years of paying rent and being ignored by management, you withhold rent out of desperate rage. You're just simply fed up with nothing ever happening in your apartment. You're prepared to pay what you owe to the landlord. All you want is for the apartment to be brought up to code. You might then, in eviction court, pay what you owe. Nothing gets fixed. And then the landlord jacks the rent afterwards to reinforce the unspoken rule in these apartments, which is shut up or get out. Of course, there is no getting out for so many tenants. This apartment was already the last resort, and now you have an eviction on your record. So it's no exaggeration to describe the private rental market in Rhode Island, especially its affordable segment, as lawless and abusive. We must guarantee tenants the right to counsel in eviction court, and we must enact a tenants' bill of rights that prevents landlords from price gouging and from evicting people who have been broken by their landlord's price gouging, or worse, evicted in retaliation for demanding safe and dignified homes. Thanks, everyone, for your time.
Thank you for your testimony. Carol O'Donnell?
Good evening. Thank you to the committee. I'm from Rhode Island Coalition for Housing Providers. I'm also president of Rhode Island Builders, and we also own apartments personally. We are not a landlord that lets our properties go. We improve our properties. We are not a landlord that hits anybody when they're down. We actually work with them, take payments, and sometimes it'll take them a year to catch up. We don't like to go to eviction court for our sake and for the tenant's sake unless we don't have a choice. I do understand there are owners of apartments that do take advantage of people, but I would say not all of them by far. And we own quite a few apartments, my husband, for over 50 years, and that's not us as well as the people that with the coalition. What I do find is some of these bills are unrealistic with their proposals. A 4% increase. I can tell you in the last year and a half, our cost had gone up over 10%. We supply heat to most of our rentals, hot water, insurance, taxes. Our taxes in North Providence have gone up so much that it's like we have a building that we don't own. So it would be unrealistic for us not to be able to increase the rent higher than 4%. We wouldn't be able to maintain the buildings. We wouldn't be able to insure them. We wouldn't have trash pickup that's nearly doubled. So I think as much as we want to protect tenants, we need to look at the landlord basis also. Because there are tenants that are career tenants that take advantage of landlords, that destroy apartments. We've had that happen. We don't even go after them. We just cut our losses and let it go. They're destitute somewhere to do things like that. But I think we need a balance with the landlords, that we're housing providers. We're not just people in to make money. Some of our buildings need to pay for our other buildings because costs have gone up so much. We can't increase. We have good tenant bases. We've had our problems. We've rented to people right out of being incarcerated. We work with House of Hope. We work with Amos House. We work with individuals that maybe some people wouldn't work with, but we need to know their background. We need to know who's in our buildings so we can know where to place them better. And I think that some of these bills are just a little bit too far without realizing the impact on the landlords and with realizing that not every landlord is painted with the same brush. So I would hope we could have some moderation to look at this. Thank you.
Thank you very much. The next three are Chelsea Fernando, Yanino Costado. I probably really killed the name, sorry. Richard Addison. Is Richard here? Yep, there he is. Okay. So Chelsea, you want to start?
Good evening. My name is Chelsea Fernando. I am the senior political organizer for the Rhode Island Working Families Party. I'm here in support of all of the tenant protection and housing bills in play tonight, and in particular, Bills 6062, 5899, 6129, and 6238. I'll get this out of the way. I've said it before in this committee, and I'll say it again. If you are a landlord of any size, of any magnitude, if you are unable to keep your business in the black without upcharging your tenants more than mandated in 6062 4%, that is not a problem with rent regulations, that is a problem with your business model. I'll keep my comments brief since there are a lot of directly impacted folks or more immediately directly impacted folks here in the room tonight. But I will say the magnitude of the housing crisis is immense, and the Working Families Party, as well as Reclaim Rhode Island, of which I'm also a member, sees this suite of bills as very simple solutions to complex systems of exploitation that target specifically historically marginalized groups like people of color, queer people, people who have been formerly incarcerated, which in itself is already a cycle of housing instability and discrimination. I think I'll speak specifically on Representative Boylan's bill, the radon testing bill, because it hasn't been spoken on very much tonight. I see that bill as a prime example of a hidden threat to working families and to working people. Radon is an issue that I've dealt with personally as a tenant. Radon is present in the ground, so it's it's pervasive in basement apartments, and something that we generally know about basement apartments is that they are rented for prices that are much lower than perhaps the rest of the building. Who is most likely to go for apartments that are rented for cheap? Poor people, people of color, people with poor credit. Testing for radon would allow people who are marginalized from taking further hits to their quality of life, at least give them a heads up to what they might be getting into. If they're already renting an apartment as a last resort. The last thing I'll say is I've looked at the testimony that's been submitted to this committee tonight, and I've heard some of the testimony as I've been sitting here in the back, and thank you all for your patience in listening to all of it. Many mom and pop landlords have submitted testimony opposing these tenant protection bills. And I've been sitting here and I've been thinking, it is quite difficult to be a small business owner, in this economy. But I wonder if there's such a thing as a mom and pop tenant. We don't really hear about those because that's just, I don't know, if you're a mom and pop landlord, if the state fails to protect you, then you might lose out on your profits. If you're a mom and pop tenant and the state fails to protect you, then you'll lose out on your life. I guess I'll let the other two witnesses speak, but I'd like to say that the Rhode Island Working Families Party, Reclaim Rhode Island, and I personally, as a first-generation immigrant queer woman of color who is a mom and pop tenant, I would strongly support all of these bills and urge you to act boldly in the face of this housing crisis that threatens so many of our siblings, brothers, and sisters. Thank you very much.
Thank you. Yanino, am I saying your name right?
No, but it's okay.
Oh, why don't you tell me what it is?
My name is Yanine. I'm currently here, not affiliated with any group, but am supporting, tenants and tenant rights. I'm here supporting a bunch of bills, and I know that I won't be able to, speak on all of them, but like Chelsea said, yes, House Bill 5899, not a lot of folks talked on it. This is probably what lead was in its early stages, when there was information being brought out about that, so definitely in support. Another bill that I'm in support of is 6062, a tenant bill of rights. It seems common sense after hearing all the stories, that tenants clearly are not protected or do not have enough structure in the system to receive assistance. So that feels like a no-brainer to just pass, just saying. Then, in support of 6129, this one I do have a little story to tell because fortunately I was able to help out at the eviction help desk at the court system in Providence and in Warwick. And with that opportunity, I was able to see just how amazing the lawyers are, running back and forth from case to case, from lawyer to lawyer, from tenant to tenant, making sure that they can get, give as much assistance as they can, within their capacity there, in the time that they have, because also they're not meeting these tenants prior, it's like you get the information super fast, you figure out what you can do to settle or to get the person to stay in their apartment, and a lot of times, right, the lawyers are helping them settle the case, and a lot of these cases are because of just non-payment, which means that we just can't afford rent, and that's why people are being evicted. That just highlights other issues, perhaps, and I know that folks were not really super supportive of the 4% increase cap for, in this bill, or in 6062. But yeah, definitely think that that's super critical. 6129, also super in support. I think that's the diversion program that I wanted to say that, great program. We need to support it, fully fund it, please, if we're not doing anything else around eviction, you know what I mean? Just bare minimum stuff. Also in support of 6197, because discrimination, right? Do you want to keep having that? Let's be on the side of progress here. And then also in support of all of the lead bills. I mean, the AG's office is doing pretty awesome work. I'm glad to hear about this public protection campaign work that they're doing on behalf of the public. That makes me feel a lot safer knowing that I have rights or someone's working on rights for myself, right? And again, we're hearing these really sad stories about lead. I don't even know if I've ever been lead poisoned because this problem has never came across to my mom, but I'm sure if I were to tell her now, she'd be like, there were some sketchy apartments that we were in that we probably could have had a case for. So all in all, please support these great bills. This is a really great committee. I'm sure everyone here will be on the side of history that will reflect highly on this reform. So thank you.
Thank you very much. Richard?
Okay. My name is Richard Addison. I'm an 82-year-old resident of the city of Pawtucket. Except for the 4 years that I was in the U.S. Marine Corps, I've lived in this state of Rhode Island. I learned a lot more recently because I started to get more involved with things that I should have gotten involved with a long time ago. Representation. This is the group of representatives. And I'm saying, without representatives, there's no justice. The representatives are the ones who have to speak up for the people in their community. You were elected to speak for the people in your neighborhood. You were elected to be our big brother or big sister. You're our protector, because without representation, there is no justice. And that's what happens when I started thinking about a person going to court. Criminal, civil, no matter what type, traffic court, if you have a representative with you, you got a better shot. If nobody's there to represent you, you're in serious trouble. But the lawyer said, a lawyer who has himself as a client, a lawyer who defends himself as a fool for a client. Well, that's the truth. You better have somebody who genuinely cares about your situation and your quality of life. You people have accepted that as a challenge. You become the representatives. The other side, they make the laws, they're the Senate. But you people here are the people who are taking care of us. Now, I'm a senior citizen, and I'm going to tell you, when you get to be my age, when you have the fear of eviction, that's a terrible feeling. I want you people to think of us as Nana or Papa or Grandpa or something. We're the senior citizens. When you're 80 years old, when you're threatened with an eviction, that's like getting a prison sentence, or even worse than that, a death sentence. Because in my building, recently, they have used the eviction as a threat, the threat to control people. People who have no idea. Fortunately, and I know she's going to get mad, fortunately, we in District 58 have Sherry Cruz. And I'm telling you, it has been a blessing to have this young lady come to represent District 58 at the State House. She is 999% hot. And I'll tell you what, that other 1%, she's a Cruz. You gotta find out where that came from. But I'm gonna tell you, seriously, when we can guarantee that when a person is being evicted, that they don't have to go to the court by themselves, especially if you're a senior citizen. Some of them who have limited educations, you go back 65, 70 years, 80 years, a lot of these people didn't have the same opportunities that some of you people had to go to high school, graduate from high school. You come from a large family, as soon as you got 16, you get a job because everybody needs the help. We need the income. So a lot of the senior citizens that are living in our houses, and then we have immigrants who come from other countries, who've been in the country for 10, 15, 20 years, worked hard, paid their taxes, but they don't really understand the English language. They don't really understand the whole concept of this Constitution and the Bill of Rights and this and that. But now it's our responsibility to help these people. I'm going to tell you, I got a letter the other day from the Pawtucket Housing Authority that after 15 days in arrearage, you are, wait a minute, the rent you owe, some or all are in arrearage. I read this and I said, what is this? It's a threat. When they showed me the amount of money that is my rent, and it said some of it is missing. I had to go back to my files. I took out all my rent receipts. I mean, not my rent receipts, the money order receipts. The sum was $10. $10. It was supposed to be $362, and my thing was $352. $10. And they throw this in you, and then they say you got 30 days to make restitutions. I said, well, if they had called me the next day, I would have given them the $10. But this is the threat that they use to hang over your head. This is what they do. We have people who had to call legal aid. Now, one of the girls said she called so-and-so, I'm not going to mention her name again, but that person helped her out and they got legal aid, and they had 4 justices and 4 lawyers representing her at the court. And that's what happens. The woman came home and she said to me, Richard, I can't believe it. She says, I have been blessed. God has blessed me, because she said, I didn't know what I was going to do. 80-something years old with an eviction. Where was I going? Got no family, no friends. She said, but now I got a shot. Now that I have lawyers, and we're going to work out the problem. I don't know where district you people are from, but I'll tell you, if you really want to make your constituents happy, do like they do in 58 with Sherry Cruz. Thank you very much.
Thank you, Mr. Addison. Thank you for coming out.
I know I would get her.
Aw, he's sweet.
I just wanted to say thank you, but everything you said is 100%. When we think about our senior citizens,
yes,
our veterans, and to see they have nowhere to go or they're about to be on the street.
Terrible. For
Nothing else
$10.
to
For $10.
So thank you for coming out, Mr. Addison, and sharing that, definitely, and keep advocating.
Next is Deborah Levy, David Sisson, Stephanie Barbusi. Why don't you start, Deborah?
Thank you. Thank you, Vice Chair, Chair, all the other members of the committee, and thanks for your patience in hearing from me tonight. There were a lot of important lead poisoning related bills in various committees. I appreciate you all sitting through all of this testimony tonight, because I know we're all here because we really care about this. These are important issues. These are issues we're dealing with every day and that our loved ones are dealing with. And I hope that that same care for our community is also keeping you interested in listening to us through all of these long testimonies. So my name is Deborah Levy. I'm a community organizer at the Childhood Lead Action Project. I'm here to testify on behalf of the Childhood Lead Action Project in support of Bills 6201, 6238, and 6239. We also submitted written testimony on these bills. The Childhood Lead Action Project has been around for 30 years. Our mission is to eliminate childhood lead poisoning in Rhode Island, and we're the only organization, both state and we're the only organization in Rhode Island focused specifically on lead poisoning. We've worked with hundreds of families over the years. We do direct support. We talk to people about lead poisoning, and we also work with city governments to enforce the lead poisoning laws that we helped to pass 10 or 15 years ago in this state. Lead poisoning is entirely preventable. It's a significant children's health issue. I'm not going to repeat things you've heard already, but it's one that's preventable, and we know how to prevent it. It has a straightforward answer. Remove the source of the lead. Make sure the places are safe for people to live. We have great laws that already require these things, and you'll eliminate lead poisoning. We're in the job to put ourselves out of business. That's why we're all here, to make sure that we don't have any more of these problems coming up. Like I said, we've helped lots of families who were in lead poisoning crises, including some of the families you've heard about tonight, and we're lucky to work with some of the other organizations in this room to be able to do that work together. As you've heard, renters in particular are at high risk from lead poisoning because they don't have direct control over their living circumstances, and they don't get to make the decisions about what happens in their homes. I especially do want to talk about 6239, the registry bill, because it's something that finally would put in place a way to proactively enforce lead laws we've had for 15 years. You've already heard about the high rates of non-compliance in rental housing, even though we have some of the best laws in the country around this. And I know that you've heard a little bit from the Attorney General's office about other states that have done this proactive enforcement well, but we actually don't have to look for other states. We have examples right here in Rhode Island of how this could work. The city of Central Falls has been using a point-in-time list of non-compliant properties that was produced for them by the Department of Health. That list is 900 properties, thousands of units. They've been using that list for the last year and a half. They've brought more than 400, probably close to 500 units into compliance in the last, I think, 16 months by using that list, because they actually know where the properties are. They know that they're non-compliant. And last I checked with the city, they've done that without charging a single fine. That is almost 500 apartments made safe for children to live in without fining landlords because they have the data that this bill would present to the entire state. And they're able to work with those landlords, refer them to financial resources. Many of the landlords they talked to had no idea this was even a requirement. This bill is not only about helping tenants, it's about making sure that we know where there are people who are providing a business, renting out their home to a tenant, and can provide them with the information they need to be able to do that in a safe way, where they won't end up getting sued by the AG's office for hundreds of thousands of dollars in damages. We need this package of legislation to incentivize compliance, but also to provide those resources to property owners. I won't get too much into many of the other details, but I am happy to answer any other questions about our work with code enforcement departments in all the core cities, about our work preventing lead poisoning for the past 30 years, anything you want to know that is more detail specifically about lead, Rhode Island's lead laws, or what it's like to actually be the people working on the ground with these. And then I do want to say, on behalf of myself as a Providence renter, so not on behalf of my work, on behalf of myself as a Providence renter and also a member of Direct Action for Rights and Equality's Tenant and Homeowner Association, I would also like to state my support for the Tenant Bill of Rights 6062, Tenants' Right to Counsel 6129, and Fair Housing 6197. I have been a renter in Providence for many years. I am not originally from Rhode Island, but part of the reason I moved to this state is because I wanted to live in a state that had better protections for people. I want to raise my family in Rhode Island. I would really like to see some of these things passed so that I know that my rights are protected. And yes, so I want to say that. I also have worked with lots of tenants outside my job. I've done tenant organizing on my own time. I've heard many, many stories like the ones you heard tonight. Just when you think you can't hear another story like that, I hear from somebody else who's telling me the same thing. They have cockroaches, they have mushrooms, they have lead. Their landlord is harassing them, calling them slurs, charging them much increase in rent. I hear about landlords who, tenants who are getting defrauded because they don't know who their landlord is, and a guy is coming to their door every month and taking their money, and it turns out that person is not the landlord of their apartment. This kind of thing is happening all the time. If you haven't been a renter in a while, maybe you forgot, but I hear these stories at my job and from my friends and from my neighbors and from people I talk to constantly. These are really important pieces of legislation. I thank you for your time, and again, I'm happy to answer any questions.
Thank you, Deborah. David?
Good evening. Can you guys hear me in the back?
Yeah.
All right, thank you. My name is David Sisson. I'm an architect. I'm currently in process of creating over 500 housing units in the state of Rhode Island and a further 300 in the state of Massachusetts. I'm also a property owner, makes me a landlord. Coming here to speak to you tonight on these various bills you've brought forward. Now, first of all, regarding lead, we've all heard some tragic stories this evening regarding lead, and I would agree 100%. This is tragic. However, the state of Rhode Island already has one of the strongest lead laws in the nation, and as we've heard, it's not very well enforced. You want to create more laws without funding for an enforcement mechanism, except to penalize landlords, including allowing tenants to put their rent in escrow, and they can't be evicted. So what's to stop a tenant from putting rent in escrow and stop paying rent? How is the landlord going to repair the unit? Let's talk about that. Let's talk about the practicality of keeping a unit in lead compliance. We heard from a lady this evening who sounds like she's in a very tragic situation where there's paint flying off the walls and ceilings. That landlord's not doing the right thing. I'd agree 100%. We work hard in our units to keep them clean and safe. We just flipped over a 2-bedroom unit, $4,000 to deal with peeling paint. We paid it. Now, where are we going to get that money on units we're making about $100 a month off? We're just eating it, so we're losing money on those. Now you say 4% rent increase a year. A lot of our tenants, we don't raise the rent each year. We want to keep them in there. We like them. We want them to have a safe and nice place to live. We spend probably more money than we're making on some of those units. Believe me, if you mandate 4% a year, guess what we're going to get? We're going to get 4% a year every year, year in, year out. We're just going to write it in. It's just going to happen. I got tenants who've been in 4 or 5 years with us who've never gotten a rent increase. I got to rethink that, I guess, because you guys keep coming back with these bills on rent control. Now, are any of you landlords, you ever owned a house? Ever known what it's cost to take care of a place? It's very expensive. Don't make a lot of money on it, to be honest with you. Okay, I think you get my drift on the lead law. There's a lot of penalties in here for landlords, a lot of penalties. No funding for remediation. Rhode Island's got a very old housing stock, we all know that. A lot of it's got lead paint on the inside, outside, it's in the ground. We didn't put it there, it happened before we were born. You aren't putting in any money to clean it up. Maybe think about that. Okay, couple other bills you got in here. 4% rent rise yearly, we talked about that. But rent control is well known not to work. We all know cities that got rent control, very expensive cities, New York, San Francisco. What does rent control do? First of all, it takes a lot of units off the market because people like me see it coming and we condo the buildings, we sell them. Second thing is, the folks who are in those units maybe got nice rent. What about people who want to move into town? What about people who want to move out of their parents' place into their own place? Does that help them? I'm sure you all know these arguments because you wrote the bills. You probably thought about the other side of this when you wrote it. A couple other bills in here. A lot of this, honestly, it's mandates that are already covered in other law. For example, the assistance animals. We all know ADA, Title II, Title III covers assistance animals, trained animals that help people out. We also got fair housing, does the same thing, and also covers emotional support animals. Why do we need legislation that's already covered in existing law? Now, regarding some of these other tenants' bills of rights, you stuck in, can't consider criminal record, can't consider credit score. Good idea, right? Get the folks who need housing, get them housing. But as a landlord, how am I supposed to evaluate these people? Any of you have neighbors? Do you want to live next to rapists and murderers? We've had those people apply. Some of them, we consider what they did. Is this worth considering having them in? Maybe it is, maybe it isn't. We want to consider it. We want to have the option. Same thing with the credit score. We house people with low credit score. That's not necessarily a deal breaker. But you don't want me to even be able to consider it. How am I going to compare this person to this person? It's a business decision for us. And if we're going to lose money, we might rather keep the unit empty. You want to house people, give us some tools. Give us some tools to work with. Finally, you'd say you want to give the tenants the right of refusal on the sale of properties. Interesting idea. They already got it. They can buy a property when it goes up for sale. They're for sale, right? But you exclude single-family homes. So what does that mean? What are you talking about? 2-family homes, 3-family homes, 4-family homes. It's not 5-family homes and up because those are commercial properties. Entirely different lending scheme. To be honest, you want to buy something that's 5 units and up, it's a huge challenge, even if you got money. Huge challenge. Why? Because of the lending requirements. It's not the same as buying a house. So 2 families, 3 families, and 4 families. Those are the houses you're trying to give right of first refusal to the tenants. Oh, wait a minute, which tenants? 4 units, 4 tenants, 60 days each. What if 2 of them want to buy it? Didn't think about that. Finally, insects. As a landlord, we take that pretty seriously. We don't want insects in our place. We spend a lot of money to make sure they're not in the place. Don't always nail the tenant to the wall on that. Try to consider each case by case. But a lot of times, honestly, those are coming in because tenants didn't clean up. We can't mandate that. We can't mandate that tenants really keep the place clean. We don't have that in our toolbox. I don't think it's really fair to us to be nailed every single time. You guys had an interesting one that came up a few months ago about bed bugs. And you kind of said, well, if it's in one unit, it's the tenant's fault. If it's in multiple units, the landlord's got to take care of it. That seems kind of reasonable. You know, if it's spread throughout the property, I don't know how one tenant can just necessarily take care of that. So I think that covers most of what I had to say. Thank you very much for your time.
Thank you.
And
Thank
I'm
you for
happy
your
to answer any
testimony.
questions you may have.
Stephanie?
I want to first start off by saying, so it was on, sorry. Can you hear me? Awesome. I want to first start off by saying, obviously safety is the first concern for everyone, right? Especially our children in Rhode Island. I have a tattoo on my wrist. It's my niece. She passed away. She died of brain cancer when she was 9. And she was actually in the hospital for lead poisoning when she was 6. And she started growing hair where she shouldn't have. She had a tumor, I believe it was her pituitary, but it was directly related to the lead poisoning. So when I tell you this is a personal issue for me, it's real, okay? And yes, I am a landlord. But do I agree with all the practices that you guys are proposing to remediate? Not necessarily, right? I do believe that we need safer homes. And one of the reasons why, before I forget, is because she lived in a family home. It wasn't rented. So what? The kids who live in owned homes just buy to them. They're not tenants, so what, they don't get help remediating, or they don't, what? If we're going to talk about all the kids in Rhode Island, let's talk about all the kids in Rhode Island, not just one subset, right? What about our municipalities? Can anybody here tell me if our schools are remediated? Municipal buildings? Water lines? No? Did you know a lead inspector won't even come out if there's wooden windows in a municipal building? Or any building, rather. Any building, a lead inspector will not come out and test that building until all the windows are changed over to vinyl. So, how many hours do kids spend in school? How many hours do kids spend outside of the home and in other buildings in Rhode Island? Daycares, schools, other places, right? So we're making this about landlords, which tends to be the theme here, right? We want to vilify the landlords. It's all on the landlord. All the onus is the landlord. Every time I'm here. And it's really frustrating for me. I work 90 hours a week. I'm a single mom. So for me to be here, literally, it takes a lot. I had to find care for my son. Somebody else couldn't pick him up. I had to get somebody else for him. I'm running in and out of here trying to make calls because they won't pick him up. They won't release him to somebody else in daycare. So for me to be here, it takes a lot. Not every landlord is corporate. Not every landlord is unknown, right? There's people like me out here that own homes, and a lot of us too. And to his point, we seem to be targeting 2 to 4 family homes as well, which are mom and pop owned. So that brings me to the way that you guys are trying to go about this whole lead mitigation issue. So Rhode Island actually does receive federal grant money to remediate. There's actually programs through Rhode Island Housing to remediate already. But the municipalities in the state aren't working. Why isn't the state funding this without restriction? Why isn't the state funding this for our schools, for our infrastructure? Right? No, we want to say, okay, landlords have to remediate, landlords have to remediate. No, let's remediate the whole state. Put that money towards the whole state, including 2 families, 3 families, 4 families, 5 families. So that program, open that up. Instead of saying, okay, you have to have 80%, the program through Rhode Island Housing is 80% of median income, okay? So you have to meet certain criteria to get that grant money to remediate these issues. Why? Why is that a thing? So once again, the state receives federal grant money for that. So let's utilize it. And instead of making punitive restrictions and programs, let's use the funding that we're getting and actually start creating solutions to issues instead of creating more laws and more things that are going to cost us more tax dollars. Right? Let's use what we have. You know, you keep trying, another point I want to bring up is that you keep trying to hide rent control in all these different bills. You keep trying to slip it in the tenant bill of rights and this and that. And I have to come back here and fight with you guys every single time. And it's rough. I have to take, once again, time out of my day to come fight for something I own. This will, I can tell you this. This will affect tenants more than owners. And here's why. I bought my houses all for under $200,000. My rents reflect that. If I have to keep coming back here and fighting, I'm selling off my Rhode Island everything. And I'm going to sell them for upwards of $450 plus. Do you know what that's going to do to the mortgage? That's going to raise the mortgage now on a $450,000 house. The mortgage will now be somewhere around, I don't know, let's rough it out, $3,400. Or actually, I did the math, $4,252. So let's say your average two-family that's selling for $450, the mortgage with taxes and insurance, which is not including utilities, sewer, water, everything else, $4,252, split that in half. What's the rent on that property just to cover the mortgage? So my units that I rent for $900 to $1,000 are going to now, that property is going to get flipped, somebody else is going to buy it, and I'm going to wash my hands. And that new owner is going to be charging way more than $2,200 for that same property in rent. So people aren't just upping rent because they feel like upping rent. Houses are turning over and being sold. And people coming in and buying them, whether you live there or not, you have to collect rent to support that mortgage. And if you look at house prices and what they're selling for in Rhode Island, that's where you're seeing things go up. Not only that, but taxes went up, insurance went up. Taxes can almost double. There's not a cap on anything. There's not a cap on insurance. There's not a cap on taxes. There's not a cap on utility bills. Matter of fact, I just got a shutoff notice from Providence Water. So you want to cap them for me? That would be nice. Maybe we could get some regulation on that. I mean, that would be awesome. So my point being, why are we, we're worried about just one subset of the population. Why not remediate schools, municipal systems, municipal building? Is our infrastructure free of lead in the water? Do the schools and municipal buildings have lead certificates and radon mitigations? In a study done by Touro University, children spend more awake hours at school than they do at home. We all care about safety, but to vilify and put the onus on just landlords is wild. Why not do this for single families too? Single families could have lead. And like I said, what percentage of total rental properties versus homeowners' kids get lead poisoning? In Rhode Island, there is actually a study done on the water. You can look it up right on, what is it? I believe it's a Rhode Island Housing, oh no, here it is. Department of Health. So on a Department of Health study, out of around 1,100 samples collected, 6% had results that exceed the level of 15 ppb that has been established by the EPA. Most of the results higher than the EPA action level have been from faucets. Samples taken during the summer months are often higher because water has been sitting in the pipes for a long time. So can we put my tax dollars in escrow until our infrastructure is remediated? I mean, really, what are we saying here? It's logical, right? Based on what you're telling me.
or based on what these bills are saying. So I agree with Ryar when she said that we need to help and create programs to change this instead of being punitive, because it's a bigger issue than vilifying landlords. Okay, so furthermore, professional radon testing costs homeowners an average of $840, with costs typically ranging from $310 to $1,420. Remediation is a minimum of $3,000, and in Rhode Island we're 11th highest taxes in the country, second worst in infrastructure in the country, according to the U.S. World Report. What are we doing to remediate these issues, like I said, outside of just talking about landlords? And just on one more thing, pertaining to lawyers and public representation, once again, we're creating more legislation that costs us more tax dollars in the 11th highest taxed state in the country. So you want 90 more attorneys to come in. More lawyers equals more tax dollars. The public defender's office is already overworked and underfunded. We're using more tax dollars to police people. And then on the other end...
It's time to wrap it up. You've had
I
quite a
will
bit of
wrap
time.
it up. One
Please.
second. On the other end, would low-income landlords have access to these public defenders as well? Because not all landlords are above the median range. So that would be a question that I would have. To evict somebody who's destroying your property as a low-income landlord, would you have access to that public defender as well? Or is it just one side? Do we only care about one low-income population, not another?
Well, thank you for your testimony. Next is Mohammed Diakite. Sorry if I ruin the name. Elijah Gizzarelli and Angelo. Is it like Rinaldi, or is there an Angelo in here? Oh, come on, yeah. Couldn't read your last name. Come on forward. Okay, why don't you start? Go ahead.
You want me to start?
Sure.
Cool.
What's your name?
My name is Elijah Gizzarelli.
Elijah. Okay, go ahead,
Yes.
Elijah.
First off, good evening. Thank you for coming, especially the people who are still here. I really appreciate it. Secondly, I have been a lifelong renter in the state of Rhode Island outside of the 5 years I spent in the U.S. Army. I've always been a renter. And I come here to hope that you guys vote down each one of these bills, okay? Look, I get a sense from the committee and from a lot of the people who have testified today that they have great compassion for people that are downtrodden, people who are tenants, people who are trying to make ends meet. And I promise you, these bills will make those people's lives worse, not better. I promise you that, okay? So a couple of the previous testimonies did touch on a lot of the reasons why. So I'm going to try to go quick. It's been a long night, okay? So with House Bill number 5899, the radon test, I think that this is the most ridiculous bill of them all, okay? Earlier we heard testimony that somebody's house tested with 24 particles. That's more than 5 standard deviations over the mean, which means it's less than 1 in 10,000 chance that happens. So those 40 cigarette things is not like a thing. It's not so 1 in 4 test over the accepted level of 4, right? And if you actually look up the information on radon, you can be well over that actionable level and never have a problem. Radon deaths in the United States are 10 per 1 million people. And even that is maybe it was radon. They can't even verify that radon caused those 10 out of a million deaths. So what you're going to do is you're going to put this ridiculously expensive procedure that landlords have to go through, and you know who's going to end up paying that? The tenant. The landlords aren't going to pay that out of their pocket. They're going to raise rents, okay? Now, you might say, we got a bill for that. They can't raise it more than 4%, right? Well, that's not how life works, all right? We've seen rent control in other cities, and they're the most expensive cities in America right now, okay? What's going to happen is landlords are going to sell, just like the last testimony stated, and then the new landlord's going to raise the rent up to the mortgage level. Or they're going to evict their tenants for some stupid reason, and then the next tenant is just going to start at a much higher rent level. So if you want to raise rents and you want more evictions in Rhode Island, please vote yes on these bills, because that's what you're going to do to poor Rhode Islanders. House Bill 6062, I just covered that one, so. House Bill 6239. So a lot of people made some good points. First off, I don't like lead poisoning. I think it's a horrible thing, okay? But again, if the law's been on the books for 20 years and you're saying, well, this is just to enforce it, okay? Well, if this is just to enforce it, somebody earlier in support of the bill said compliance is the price of doing business. So you're admitting that you're raising the price of doing business, right? And then you're going to say, oh, rents are too high in Rhode Island. Eviction rates are too high in Rhode Island. Yes, these are my friends. I grew up very poor in this state. I was on Section 8 housing when I was a kid. I know people who struggle. They're my friends. They're my brothers and sisters. Half of my brothers and sisters did not graduate high school. They struggle to pay their rent. Do not do this to them. Do not pass these bills. After that,
I think you hit them all.
Yeah, I think that's just about it, yeah. But, yeah, I think that's all I got, yeah.
Thank you very much. And Angelo, last but not least.
Awesome, can you hear me?
Is the button up?
Can you hear me?
Yes.
All right, awesome. My name is Angelo. I'm a small property owner from Pawtucket.
Can you speak closer to the microphone,
yeah,
please?
my name is Angelo. I'm a small property owner in Pawtucket. I'm a proud landlord. I take care of my properties. I take care of my tenants, and I'm sick of keep coming back here to keep fighting for my rights. I'm getting sick of getting vilified all the time. I'm getting sick of constant all these bills, trying to make my job a lot harder and also make me unprofitable and make me go bankrupt, basically, what you're suggesting. For example, my insurance just went up $1,500 a year in a house in Providence. You guys gonna cap them at 4%? Real estate taxes went up $1,800 last year. You guys gonna cap the real estate taxes? Are you gonna cap Home Depot and Lowe's and the labor involved in upkeep, repairs, and all that? I don't think you are, but you trying to cap us at 4%, which, in a $1,000 rent, it's a $40 rent increase. Where I just spent 2 months ago $12,000 to replace a roof. How am I going to recover that with $30-$40? It's not possible. I can't just keep coming back and fighting for all these bills and keep vilifying me. Everything's going up, everything's getting expensive, cost of living is very high. Same thing with food costs, supermarkets, everything, fuel. But for some reason, you think that, you're gonna cap us at 4% and everything's gonna be okay. Well, everything's getting more expensive. Totally unreasonable. And the other thing about the lead, I agree that it's a safety issue and it's a bad thing to have. We have a lot of houses in Rhode Island that are over 100 years old. They have lead outside, inside, the doors, the windows, everything, and it costs many thousands of dollars to fix all that. So let's help out these landlords that need help to repair, replace, dozens of windows, doors, all that, because, unfortunately, you guys think that we're like multi-millionaires. We have unlimited amount of money. We're driving Bentleys and Ferraris. No, we don't make that much money owning property. We'd be lucky if we make like $100, $200 per apartment. And after upkeep, repairs, surprise costs, you gotta fix a hot water tank, a heating system breaks. I just renovated an apartment, and it cost me over $10,000 to do everything. Labor, material, everything is getting so expensive. And I'll only raise the rent $30 or $40. That doesn't make sense. So, consider some of these, outrageous suggestions and, the cost of doing business. And a lot of the stuff that you're suggesting is gonna actually increase the cost for all these, tenants. And we wanna work with tenants, we don't wanna kick them out, we don't wanna keep raising rent. But we have to stay profitable. We're going to lose our houses, and we're going to lose everything. So thank you for having me. I appreciate it. Good to see you again. I'm sure I'm going to be back.
Can I just say one quick thing?
Thank you, sir.
Very good, thank you
Very
both.
quick thing. If you look up the rankings for states, Rhode Island ranks the 4th least beneficial state to own rental properties. Right, I'm not saying that we should be the first beneficial for landlords, but maybe around 25 would be a good mark, right?
Thank you.